Good afternoon, everyone. We've got a final plea calendar and a bonus plea attached to it. Let's figure out who is here, who's on bond, and then we can figure out who's here, who got brought over, and we can make a plan. Is Mr. Creamer here, Richard Creamer? He is, great. He's got two cases. Ms. Wood, you're handling both those?
Yes, Judge, how are you?
I'm well, how are you?
I'm good. I just need to speak to him. We talked earlier this morning, but I do need to speak to him again briefly after the call calendar, and then I'll have
an announcement.
Yes.
Okay. So, Mr. Creamer, the announcement is going to be either you've worked your cases out today, which would be great, or you want to go to the trial calendar. This is the last stop before we go to a trial calendar. I'll let you and Ms. Wood talk, and then we'll figure out what's going to happen, okay? Okay. All right. Position 3 is Mr. Ross? Ms. Ross. How do you say your first name? Yes. All right. Mr. Ross is here. Is Ms. Taylor your lawyer? Let's look for Ms. All right.
Okay, I got caught. Can you hear me, Judge?
I can hear you. Yeah.
Okay.
For some reason,
I got caught up trying to get.
Say that again.
This case is a negotiated plea, Judge. I was just leaving court in Gwinnett. That's why I jumped on Zoom.
Okay. If you want to wait till you get to a better spot, you don't need to get all the way here, but a better spot. Okay. You got a real weak connection. You and Mr. Ross and Mr. Peoples and I can have that conversation.
All right, Judge, that's fine. I'll log off and log back on when I get to
all right. Sounds good.
Spot. Thank you.
Thanks. So, Mr. Ross, we just need Ms. Taylor to be audible. Her driver is driving her somewhere and they need to get to a spot where there's a better signal. So if you would sit tight back there when she gets back on and we can hear her better, we'll take care of your case. All right. Sure. Rakeem James. Ms. Luncheon doesn't, I think, do criminal cases anymore. Do we know, Mr. People?
I spoke to her, and I believe this is going to be a plea.
Okay. Oh, she's here.
I'm here, Judge. Hey, good morning, good afternoon, Judge. So I had filed the motions to withdraw, but you hadn't signed off on them yet. So I was still, working on the cases. No, I mean, until you sign, I'm still on the case. So that's how I took it. But we had tried to work out a plea in this case. Mr. James had a few concerns, so I was going to see if I could try to work it out today, Judge, but if not, I would ask to be removed from the case and maybe have him reset to another final plea so that the next person has an opportunity. But, we've all been talking, so I am going to try to work it out today. Okay.
Tell me what you need to do. You need some time to talk with Mr. Peoples or with Mr. James?
No, with Mr. Peoples. We have been talking all week, Judge. So we're really super close. But if I could do a breakout room where I can call him on my cell phone, that'd be great.
Yeah, why don't you, let's get through the calendar. And then if you call him on your cell phone, you can talk. And then Mr. James, you need to stay on the call and we'll have a conversation about what's happening next. Okay. Sounds good.
I'll text you when I'm available, Ms. Luncheon.
That sounds great. Thank you.
Stephanie Elder. There's Ms. Elder. You're going to play Ms. Feely today?
I am, Judge. I believe the court is out today. I just need to iron out some last minute details.
Okay. And Mr. Jordan, this is your case. Yes, all right. So you and Ms. Wood will talk. Ms. Elder, you should sit tight. Ms. Wood will come talk to you. She is Ms. Feely's law partner here in this courtroom. So sometimes they hand cases off to each other. Okay. Bobby Bradley. We have a lot of folks online too. I want to make sure I don't ignore them, but I don't see Bobby Bradley online.
Subject to notice, the state would ask for a bench warrant and bond forfeiture.
Okay, Ms. Wood.
Judge, my last contact with Mr. Bradley was that he was going to hire Renee Rockwell. She's on his unindicted case, but I don't believe an injury's been filed in this case, and I haven't had contact with
Okay. Oh, it is Ms. Wood still of record, and we even did a change of address for Mr. Bradley, so he ought to be here. So we'll work through the calendar. If he shows up, great. Otherwise, bench warrant it is.
And Judge, may I be excused?
That was it, huh?
Yes, I
Boom.
have to get to Judge McAfee's courtroom, but I can come back if Mr. Bradley shows up.
One of your colleagues can reach out if we get a Mr. Bradley. Okay, thank you. Position 8 is Kanisha Smith. I think I saw Derek right online, and there's Ms. Smith.
And Ms. Smith is online. Your Honor, I think we're on for case management. I just was in the process of sending Mr. Peoples' email. I see where there's a certificate of discovery, but I don't see where I actually received it. So I was going to ask to be able to get them to send that to me and then see if we can figure this out. I do have an offer from Mr. Peoples that I need to convey to my client, but without the discovery, it's not quite the substantive conversation that I can have with her as of yet.
Okay, it's actually final plea, not case management. I do see that in June, there was, right after the scheduling order, was entered in this case, there was a certificate of discovery. There was a evidence.com link that had indictment, witness statements, an APD call for service. Is that like a 911 call? We don't call them 911 calls anymore.
Some of them are labeled differently.
Okay, medical records, presumably for the alleged victim. So that got pushed out there. I don't know if you were counsel of record then. Have you always been Ms. Smith's lawyer?
For the most part, I did a substitution of counsel, but I Judge, I'll take responsibility that for some reason, I'm not saying the state hasn't done what it's supposed to do. I just did not. I don't see where I've received it, where I either have not seen where I downloaded it or I did and it's misfiled, but I just don't see the discovery.
Well, what about this proposal? I will preserve Ms. Smith's final plea rights. In other words, she could choose to enter a plea at a later date. I'm actually going to tell you that date shortly, and withdraw it if she doesn't get a sentence along the lines of what you've asked for on her behalf. This is on a trial calendar now. It's not a published trial calendar, but at the end of October, this case will be on there, and I'd like to keep it there. And you could reach out to Mr. Peoples. He can get you a new evidence.com link, but it sounds like he or Mr. Jordan, if it was Mr. Jordan's case back then, one of them teed it up for you, and we don't need to worry about why you didn't get it. You don't have it. But just in looking at what that record consists of, I don't think it's going to result in all sorts of motions from you. If it does, we'll hear those, but my preference would be to keep Ms. Smith's case on its current trajectory, have it on that end of October trial calendar, but simply preserve her final plea rights. And if you and Mr. Peoples sort something out well before then, let's get everyone into court.
That's perfect, Judge.
Okay. Mr. Peoples, anything you want to add?
Nothing further, Your Honor. I'm reaching out to my legal assistant to have a reset now.
Okay. And what will be resent is an evidence.com link.
That's correct, Your Honor.
Do those have a shelf life? If Mr. Wright doesn't click on it in 48 hours, it's no longer good, or how does that work?
My understanding is that my understanding of technology is that the link is available for, I think we send it for about 365 days, so he should be able to access it that long.
Good. Well, this one will be, that's a duration that'll work for us. All right. Mr. Wright, anything else on behalf of Ms. Smith?
No, Your Honor.
Ms. Smith, do you have any questions about what we just discussed?
No.
Okay, so what's going to happen is Mr. Wright will get the discovery in your case, a police report. It looks like there was at least one statement from a witness. There's some medical records, a few other things. And then he's going to sit down and talk with you about that. You guys will figure out, are there any motions that need to be filed? If not, then you and he will want to be talking with the prosecutor about whether this is a case that should be a trial, or if it's something that can be worked out. I will see you at the latest at the end of October, Ms. Smith, when we have the calendar call. You'll need to show up for that. That's not one where you can dial in. You'll need to be here in person. But Mr. Wright will explain that to you. But I might see you before then if Mr. Wright and the prosecutor work something out with your case. And it may well be the way it works out. You can appear virtually like you did today. Okay?
Okay.
All right, Mr. Wright, anything else?
No, Your Honor.
Thank you for your time.
All right. Thank you, Judge. May we be excused?
Yep. Nicholas K. In custody. Oh, okay. Yep.
And I expect this to be a plea today. I just need to talk to him real quick and then people one more time.
Okay. Jordan Weatherford. Right here.
He's also my judge. I need to speak with him and then I'll have an announcement.
All right. So Mr. Weatherford, Ms. Wood will chat with you and then we'll figure out what's next for your case. Damian Francis is online, and Ms. Fuller is online.
Good
Hey, Ms.
afternoon, Judge. Good to see you.
Hey, good to see you. What is happening with Mr. Francis's case?
Judge, we've received a plea offer. Our announcement, the plea offer is extended through September 21st. We'd like the plea offer to remain open, but we have an announcement already at this time. There are probably 3 or 4 things that we've asked, additional discovery items that we'll need. There's a that we've discussed with Mr. Jordan, and he's promised to get us the items that are in his possession. But short of that, Judge, we're ready for trial to be placed on the trial calendar.
Okay. So why don't we just get all that on the record? So Ms. Rivers, are you ready?
Yes, I'm ready.
Great. This is position 12. It's 23 SC 187470, State versus Damian Francis. Mr. Francis is appearing virtually with his lawyer, Ms. Fuller. Mr. Jordan is here in court for the state. Mr. Jordan, what is the state's offer if Mr. Francis were to enter a plea to the one count in the indictment?
Your Honor, the state's offer was actually to reduce the sole count of child molestation to sexual battery, and for that sexual battery to be treated as a misdemeanor. The recommendation for that count was 12 months to serve 4 months. I believe that Mr. Francis served approximately 124 days in custody, the balance being probated. The special conditions of probation that Mr. Francis have no contact with the victim and the victim's immediate family, and also that he undergo a psychosexual evaluation and follow any recommended treatment.
Okay. Ms. Fuller, was that your understanding of the offer that the state communicated?
That is correct, Your Honor.
Okay. And Ms. Fuller mentioned, Mr. Jordan, that offer actually had a expiration date beyond today. Is that also correct?
That is correct, Your Honor. I did not extend the offer. I wanted to make sure that I talked to the victim's family as many times as I could to discuss the offer with them before I conveyed that offer. So I did leave that wide of a window for the offer, Your Honor.
Okay, got it. Well, today is the day for final plea. So Mr. Francis, if that was an offer you were interested in pursuing, if you entered a plea today and I were to sentence you to any more than what your lawyer asked for, you could, with no questions asked, simply withdraw your plea. Judge, I was comfortable with what my lawyer had negotiated, but Judge, you've given me more and I just soon go to trial on this one. So no thanks. It wouldn't be worded quite like that, but that's how it would work. And that'd be fine. No one in the future would know that you had thought about entering a plea and we just moved the case to trial. It's a little different today because the state is keeping that offer open, but I'm letting you know that after today, if you do choose to well, let me take one step back. Ms. Fuller, tell me what you think is missing in discovery.
Judge, there was a 2019 report that was made, and there was an indication of a body cam footage on that for Officer Briggs from that report. There was also a forensic interview of the minor child we did receive it. I did tell Mr. Jordan that we received it, but we weren't able to open it and watch that video, watch the interview. There was also a reference to a handwritten note that the minor child passed to the school counselor. We did ask for that to be disclosed as well.
Got it. Okay. So this is an allegation from many years ago, now that I look at the indictment, which can make discovery a little complicated. Okay. So why don't we do this? How far out did you extend the offer?
Ms. Fuller, I'm sure you have that email open, but I believe I said 21st. Yes.
Okay. Any reason why you wouldn't be able to get to Ms. Fuller that missing discovery between now and then?
Your Honor,
assuming it exists?
Assuming it exists, I know that initially when the case was indicted, they also tried to get the body camera footage from 2019, and they were given the message that the body camera footage no longer exists. I can make sure to exhaust our resources in reference to the handwritten note. And as far as the forensic interview goes, because it's an older case, I believe that, and I've explained.
It's a VHS cassette.
It's one of those particular formats where you have to pull it and drop it into Evidence Reviewer or a similar program in order to be able to play it.
Okay. It sounds like that one is the most fixable of the three. There may be no more body cam video, and who knows about that note. But I think that's far enough out, September 21, that what I'll do is, Ms. Fuller, keep Mr. Francis's final plea rights open through the expiration of that offer. After that, of course, you can still work something out. Mr. Francis just won't be able to withdraw his plea if I sentence him to more than what the state recommends. It doesn't sound like this case is heading towards a trial, given what the state's offer is right now, but I appreciate completely why you, Ms. Fuller, want this additional discovery to which you're entitled, so that you and Mr. Francis can have a full understanding of the strength and weaknesses of the state's case. I'm going to keep this case on that October 27th trial calendar because that will resolve the case, I suspect, if it doesn't get resolved by the 21st of September. But Ms. Fuller, what I'd ask you to do is, if you and Mr. Francis reach a point where you want to pursue this offer from the state before it expires, let Ms. Nelson know so that we can all connect, whether it's in person or virtually, and take that plea. Okay?
Will do, Judge.
All right. Mr. Francis, do you have any questions about anything we've discussed?
No, sir.
Okay. Then I may see you all on or before September 21. If not, then October 27th is that trial calendar date. And everyone will need to be in court for that, not virtual, to work through whatever we're going to work through. Mr. Jordan, anything else for the state?
Your Honor, I just wanted to make the court aware that the victim's father and I believe mother are present on Zoom.
Okay. Well, I'm glad they have plugged in, and they are, of course, entitled to attend virtually or in person any proceedings of this significance in connection with the case involving their child. So thank you for flagging that. And I trust your office will let them know when the next court date will be. The 27th of October would be that call of the trial calendar, but it may be before then. We're getting together because the case has been resolved.
Yes, Your Honor.
Okay. Thank you.
Thank you, Judge.
Thank you, Miss. Yes, ma'am.
Nothing further, Judge.
Oh, okay. I was going to say thank you. You are free to go.
Thank you. Bye-bye.
All right. And the final position on the main calendar is Anthony Jones. That's a probation revocation. It says Marilyn Primovic. Will that be Lacey Wood?
Yes, Judge, and this is the gentleman who the last time we had his dad instead of him.
Yeah.
So.
Do we have the right one?
Yes, Judge.
Okay.
We'll on this one today.
Great. All right. And then we have William Hill, who I think is in custody. And that's with Ms. Carnage.
Yes, ma'am.
How are you?
Good.
I'm well, and that's a plea today? Okay, all right. Then my thought would be we could take the Hill, well, that's gonna tie you up though. Do you think Mr. Jordan could do the plea? Because I know you need to talk with some lawyers, Ms. Wood needs to talk with some folks. Ms. Carnage has one thing to do here today, and that would be Mr. Hill. We could bring him out if you don't mind, Mr. Jordan, be like old times. It's not some fancy CAC case.
That's fine.
Okay. Ms. McCauley, why are you here?
Oh, just to bother you.
Good, that's the usual.
Thanks, McBurney. I am over here because I was going through my calendars and talking to Detective Smith in advance of the Reynolds motions that are scheduled. I don't think I'm gonna be doing trial on the 18th.
You think Dowdy will go?
Okay.
Good, okay. And that's gonna basically consume Judge Emerson for both weeks, as you've warned, and I've told him as much, so he knows.
And then the backup to that, just so you know, is now a 4 co-defendant in custody trial.
Yeah, I got a little message that someone didn't plead.
No one pled.
Yeah.
And then someone's back in custody.
Wow. This was all in front of Judge Carnesale?
This morning.
Okay. Hey, Mr. Hill, come on up to the podium, please. And Ms. Carnage, if you do the same.
And I'm looking at other people that are available to do those motions, because there's a lot. I don't think I have an adequate substitute for the 18th, and that's concerning, because there are so many motions scheduled on that day.
So he's on bond and you are, but you are the primary motive force on that. And so if you are saying it needs to be moved, you will manage the family.
I've already talked to them.
We can move it. Mr. Shepherd's not gonna complain.
Okay.
So,
You want me to send an email, you want me to file a motion, which?
try an email, and if Mr. Shepherd says we have no objection, then you've done it. We just have to find another big chunk of time, which is hard, but you're right. You will be in 1D, and I appreciate your desire to hand it off only to certain people, and if those certain people aren't available, then I just feel bad given the age of that case.
No, and I completely understand. I think we can knock out all those motions in one day.
But it's a day when you're available.
Right, and I'll get the materials
Okay.
to you. I just wanted to make sure before I subpoena Detective Smith, that was an option to move it.
Yeah.
So, and I was already upstairs.
Okay, well, it's always nice to see you. Yep. All right, let's get on the record with our supplemental calendar. This is 19 SC 165274, State versus William Hill. Good afternoon, Mr. Hill.
Good afternoon.
Mr. Hill is here with his lawyer, Ms. Carnage. We have Mr. Jordan representing the state. Mr. Hill, this is an old case. You are charged with burglary, and Ms. Carnage has graciously agreed to participate in our county's C3 program. I think that's how you got this case. Is that correct?
Yes, Your Honor.
Thank you for participating in that program. She and Mr. Jordan have relayed to me that you're prepared to enter a plea. Is that correct?
Yes, sir.
Okay, the way that's going to work is that in just a moment, Mr. Jordan is going to put you under oath. Once you're under oath, he's going to ask you a bunch of questions. You need to answer those truthfully. If at any point, Mr. Jordan or I or someone says something that you don't understand or is different from what you and Ms. Carnage have been talking about, will you let me know? Because I need to be comfortable that you do understand.
Okay.
You'll alert me and say, wait a minute, I don't get that.
All right.
Excellent. Okay. When you're ready, Mr. Jordan.
Thank you, Your Honor. Mr. Hill, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
William Hill.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medicine that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
25, and I completed high school.
Are you able to read, write, and understand the English language?
Yes.
You understand that you have been charged with 1 count of burglary in the first degree?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Carnage?
Yes,
Ms. Carnage, are you satisfied that your client has a full understanding of this proceeding?
yes, I am.
You also waive formal reading of the indictment.
Yes,
Do you also waive any and all defects in the indictment, including any with respect to your client's name?
correct.
Mr. Hill, do you recall having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Carnage, do you know of any outstanding warrants that are related to this charge?
I do not.
Mr. Hill, do you understand that you are entering a guilty plea to the sole count of burglary in the first degree?
Yes.
And Your Honor, for the court, the minimum for burglary in the first degree is 1 year in prison and the maximum is 20 years. Mr. Hill, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, the state's recommendation is 5 to serve 1, commuted to time served, the balance being probated. The only special condition of probation is that Mr. Hill stay away from the incident location. And Your Honor, I can get that for you right now. That was at 272 Matilda Place in Atlanta, Georgia.
That's a private residence?
I believe so, Your Honor.
Unoccupied dwelling, but.
Okay, but it's a house, it's not a
It's a house.
store,
Right,
it's a
right.
residence. Got it.
Yeah,
Okay.
Mr. Hill, are you aware that the court does not have to accept that recommendation?
Yes.
Are you aware that the court can sentence you to the maximum on this charge?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and may result in deportation?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm during the commission of a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and finally, the ability to obtain employment?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by answering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Mr. Hill, how do you plead to the sole charge of burglary in the first degree in indictment number 19 SC 165274.
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes.
Do you understand that you have only 4 years from today for this sole felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, for a factual basis in this case, on October 19th of 2018, an officer responded to a burglary in progress at the previously mentioned location.
I'm going to pause you about location. The indictment says 737 Matilda. You said 272. And it's not critical. It may be that I just tell Mr. Hill to stay away from Matilda Place, the whole street, unless he happens to live real near there.
There's actually a third different address as well, Your Honor. So if we can just have Matilda Place. I was reading from the warrant when I gave that particular location. On the police report, there's 727 Matilda Place in Atlanta, Georgia. So for the purposes of the plea, I would just ask if Matilda Place
Okay.
can be the stay away.
Got it.
And I can proceed whenever the court is
Oh,
ready.
I'm ready.
On October 19th of 2018, an officer from the Atlanta Police Department responded to a burglary in progress. The caller was a neighbor that lived across from the location. The witness advised that there were 2 Black males that entered this vacant residence through the back door and were taking items from the location. While the officer was en route to the call, an update stated that the witness had seen 2 males exiting the location with a vacuum and tubing walking down the street. The officer came down Matilda Place and was able to see the males rolling a vacuum with them down the street. The officer stopped his car in front of them and told them to come speak to him. By that time, other units showed up on scene and were able to get both males in custody. An investigator was on scene and Mirandized both males and then started talking to them separately. Both males had the same story and they stated that they were walking to the train station when they approached a male known as Jay. They stated that Jay came up to them and asked them if they wanted to make some money and told them that there was a yellow house down the street that was open and they could take what they want and he would buy the items from them later that day. The suspects stated that they did not know the individual's real name or where he lived. They just knew him from the area. Officers were not able to find a male named Jay in the area. One of the individuals was the defendant, Mr. Hill. He was arrested and charged accordingly. Your Honor, the state would ask that you accept the negotiated plea.
Okay. Thank you. Good afternoon, Ms. Jackson. Do you have any criminal history information on Mr. Hill?
Good afternoon, Your Honor. The defendant has 3 cycles. The defendant's last arrest was November the 15th, 2016 by the Martyr Police Department for reckless conduct. That charge was dismissed on February the 6th, 2017. There are no convictions listed in the GCIC. Nothing in addition, Your Honor.
Thank you. All right, Ms. Carnage.
Yes, Your Honor. And to add to that, my client does appear to be eligible for a first offender. We did want to state that to the court as well. Thank you for the criminal history, Ms. Jackson.
Does Mr. Hill want to avail himself of the first offender opportunity? I'll talk to him about it as well, but based on your conversation with him, he wants to?
I explained to him the good parts and the bad parts about first offender, Your Honor, and he did indicate to me that he did want to take first offender.
Okay. Mr. Hill, you're 25. Where'd you go to high school?
Crim.
You got arrested about 200 days ago on a bench warrant from this old case. What were you up to just before you got arrested? Were you working? What was going on in your life?
I was doing during the time, it was like day labor. It wasn't like a specific 9 to 5, but I was doing day labor jobs.
Okay.
But I was just finna add that when I get out, I got a guaranteed job with my mother doing inventory. I'll be getting paid $17 an hour.
That's a pretty serious job. Where does your mom work?
She works for Regis Inventory.
Okay. And what does that mean? Like you go to a grocery store and make sure there are lots of cereal boxes, or what do you do?
And you count items with like the gun machines and all that. Yeah.
And your mom does that?
Yeah, she's a supervisor.
Oh, so she could hire you. Okay. Well, that's exciting. Where will you live when you get out?
2129 Vineyard Walk, Atlanta, Georgia, 30316.
Okay. Is that your mom's place?
Yes, that's with my mom.
Who else lives there?
My mom, my sister, and my little brother.
Okay. Do you have kids?
No.
Were you living at that vineyard place when this situation happened with Mr. Merkson?
No.
No. Were you still living with your mom back then, or you were somewhere else?
I was still staying with my mom.
But she's moved since. I mean, this was a long time ago. This was almost 5 years ago. Okay. How did you know Mr. Merkson?
From the neighborhood.
Okay. So I didn't know where Matilda Place is. I had to look it up, but I now know where it is. It's near Grove Park, right off of Donnelly Hollowell. You're going to need to stay off Matilda Place. Is that anywhere near where your mom lives?
No.
Any reason why you'll need to be on Matilda Place?
No.
Good. Okay. Do you have any questions about anything we've discussed?
No.
First offender is an opportunity for someone like you who has no convictions. You've been arrested just a couple times and they're all old. You've stayed out of trouble real well. And so you qualify for first offender. What it means is that even though you're pleading guilty, when you get out, which you will in the next couple days, and you'll be on probation for a little bit, you aren't a convicted felon. So if you're signing up for that job with Regis Inventory and they have an application and it says, are you a convicted felon? The answer is no. Even though you've got this sentence, it's what we call a first offender sentence. And if you successfully complete the sentence, it all goes away. It comes off your record, no conviction, nothing. That's a great opportunity. That can help you with work if you want to go to trade school or college or anything like that. Everyone always wants to know, are you a convicted felon? The answer will be, I'm not a felon. You had first offender and you don't even have to talk about first offender if you successfully complete it. It's like it didn't happen. The risk is if you are going to be hanging out with someone like, I'm not blaming Mr. Merkson, but when the two of you were doing what you were doing and you're suddenly rolling someone's vacuum cleaner down the street, if something like that happens again, you get arrested, not only do you have a new situation you have to deal with, but you come back here and I could not just revoke probation, but you heard what Mr. Jordan said, the range for burglary is 1 to 20. And so if you did something particularly bad, next time around, I could say, you know what, I'm going to resentence you for this burglary, just over a vacuum cleaner and probably some copper pipe. And I'm going to sentence you to 10 years to serve because you showed us he really wasn't ready for first offender. 6 months later, he's breaking into cars or something like that. Now, if you know that what went on in October of 2018 is just not what you do anymore, and that was you were young and it was a quick buck and that was stupid, then first offender makes all the sense in the world. But if you're not sure who you're going to be rolling with and what you're going to be doing, first offender carries that risk. Do you understand the risk?
Yes.
Okay. Understanding the benefit and the risk, do you want to be sentenced as a first offender?
Yes, sir.
All right. I find there's a factual basis for your plea, that your plea was knowing and voluntary. Knowing means you've understood what we talked about. Voluntary means no one's forced you to enter this plea. Do you agree with that?
Yes.
I'm sentencing you under the Probation Options Management Act. And what that means is that while you're on probation, if you have a small issue with probation, you and probation will work through that. You don't have to come see me. But if it's a bigger deal, you get arrested again, or you're caught over on Matilda Place, that will come back to me and we would work through the consequences. It doesn't sound like there's any restitution.
No, you're right.
Ms. Carnage, do you authorize my staff to sign the indictment for you indicating your client's guilty plea?
Yes, Your Honor.
Mr. Jordan?
Yes, Your Honor.
And Mr. Hill, is it okay if we sign electronically for you?
Yes.
Great. Okay. I'm going to sentence you to 4 years to serve 6 months with the balance probated. And you've served 201 days as of today. You were in for 1 day when you first got arrested and you got a signature bond. You've been in 200 days since you got picked up. because we had trouble lining up a lawyer. It took a little while for us to track down someone like Ms. Carnage. And that's a little more than 6 months. So you're not going, well, you're going back to jail today, but you've already done more than 6 months. So you should be released this weekend. If you wake up Monday morning and you're at the jail, your folks need to call Ms. Carnage. She'll reach out to my staff and we'll call the jail saying, what the heck? And they'll get you out. But I think you'll be released this weekend. Okay. You will be on probation then for 3.5 years. The special condition of your probation will be that you stay away from Matilda Place, that one street. You can be anywhere else you want on Donnelly Hollowell, but stay away from Matilda Place. It sounds like you're going to be busy working and taking care of things. And if your probation after 2 years has gone smoothly, then I'll recommend that probation make it unsupervised. They'll probably do that even though I didn't recommend it. But in case they're wondering, my recommendation is if you get 2 years of probation under your belt and there have been no issues, you're easy to find, you show up when you need to show up, clean drug screens, all that kind of stuff, then we don't need to be looking over your shoulder. They can be focused on other folks.
Okay.
Mr. Jordan, anything else in Mr. Hill's case?
Nothing further from the state, Your Honor.
Ms. Carnage, anything else?
Nothing further, Your Honor.
Okay, do you have any questions about anything we talked about, Mr. Hill?
No, sir.
Okay, I need our probation person, Ms. Tucson, to talk to you about reporting to probation. So she is going to come alive here on our Zoom call. You're going to see her on your screen, hopefully, and we'll take care of that probation piece. Ms. Tucson?
Good afternoon, Mr. Hill.
Good afternoon.
I heard you say your address was 2129 Vineyard Place.
Yes,
And what's the zip code?
30316.
Do you have a phone number where I can contact you?
404-552-1834.
And is this your direct number?
No, that's my mother's number, but because when I get out, I got to get my phone turned back on.
Okay, what is your mom's name?
Melissa Hill, Malessa Hill.
Okay, you're gonna be contacted by a probation officer for reporting instructions. Fulton County has changed some of the reporting instructions. So as long as this is a verifiable address, you will be contacted and they will let you know when they're gonna come to visit you and do your intake, okay?
Okay.
So just be, I'll put that she is your primary contact for the time being, okay? So
Okay.
make sure that that's a good working number and that is your place of residence, because when they come to check the residence and if you don't live there or they give other information, you will get a failure to report and get a warrant.
Just like this. And they'll bring me a warrant, I'll sign it, and we'll go through this all again. That doesn't mean you can't move, but if you do move, you need to let probation know that. So staying with mom sounds like a great way to start out, especially if she's your boss. But if you decide, hey, I'm going to not be at that place anymore, that's okay. But that needs to be coordinated with probation so they know how to find you. Okay.
Okay.
All right. Thank you, Ms. Tucson. And thank you, Ms. Carnage. If you have any issues getting reimbursed or anything like that, please let me know so I can bug our court administration.
Okay, thank you.
You bet. Yes, ma'am. Have a good weekend.
I'm in my office now, Judge.
Okay. It looks like Ms. Wood is still circulating with folks. So why don't we do Mr. Ross? You want to come on up?
I have a better connection, Judge.
Yeah, you better. If being at your office doesn't have a good connection, you're gonna need to invest in some technology there.
Yeah.
All right.
Wi-Fi here. Okay.
Uh-oh. Okay. Ms. Luncheon, do you want to text through the chat your phone number? Because Mr. People said he was trying to call you and no one was answering, or it said this is Pizza Hut or what?
It just rang.
It just rang.
And I may have dialed the wrong number as well, but
he may have dialed the wrong number. But if you send just to me in chat your phone number, I'll write it down and give it to Mr. Peoples, and maybe he can dial the correct number during this next break.
Perfect.
Thank you.
Thank you.
Thank you. Okay. Let's get on the record with position 3. It is State versus Ross. 22 SC 181143. Mr. Ross is here in court. His lawyer, Ms. Taylor, is appearing virtually from her office. Mr. Peoples is here in court for the state. Mr. Ross, you have a right to have your lawyer right next to you during this plea. She is in her office instead. 2 things. 1, I'll make it so you can speak to her in private. Do you have a phone? Mm-hmm. Good. So if you need to speak to her in private because something comes up, we'll just have you step outside. You can call her and you guys can have a private conversation. Given that, are you comfortable having Ms. Taylor here virtually? So she will see and hear everything that's going on. If you all need to speak privately, I'll just have you step outside. Does that work with you?
Yes, sir.
Great. Then we're going to go forward. Mr. Peoples is going to put you under oath, ask you a bunch of questions. You'll answer truthfully. And if you've got any questions of your own, you'll let me know. Okay?
All right.
Let's go. And make sure if you move closer to that microphone, our court reporter who is invisible and working remotely needs to be able to hear everything you say. And that's got to go through that microphone right there. Okay?
All right.
Great.
Thank you, Your Honor. Will you raise your right hand? You solemnly swear that the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can lower your hand. Will you state your true, correct, and legal name?
Beyonce Ross.
Can you spell it for the record?
VEHENCEI. Last name Ross, ROSS.
Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you?
24.
And what is the highest level of education that you've completed?
11th grade.
Do you have your GED?
Yes, sir.
Are you able to read, write, and fully understand the English language?
Yes, sir.
You understand that you're charged with the with the following offenses. Count 1, theft by receiving stolen property with a sentence range of 1 to 5 years. Count 2, possession of a firearm or knife during the commission of a felony, which carries a sentence range of 5 years to run consecutively. Count 3, felony fleeing and attempting to elude, which carries a sentence range of 1 to 5 years. Count 4, criminal damage to property in the second degree, which carries a sentence range of 1 to 5 years. And count 5, possession of a firearm by a convicted felon, which carries a sentence range of 5 years. Do you understand?
Yes, sir.
So count 5, it wouldn't be 5. Is it 1 to 5? It wouldn't just be a fixed number.
That's correct, Your Honor. 1 to 5, excuse me.
Okay.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, sir.
You understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss this case with your attorney?
No, sir.
Are you satisfied with their services?
Yes, sir.
Counsel, do you waive formal reading of the indictment?
We waive formal reading of the indictment for purposes of this plea.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
We waive any defects in the indictment and anticipation of this plea.
Thank you. Mr. Ross, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court, Your Honor, we will be asking for a sentence of 10 served 1 commuted to time served. I believe Mr. Ross spent up to, I think, 174 days at my last inquiry. A weapons forfeiture, completion of a theft course, a stay away from the location and the victims to be named shortly, and restitution to Miss Lakeisha, Lakeisha Williams, in the amount of $29,500. Do you understand?
Yes, sir.
You understand, however, that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes, sir.
you understand that if the court decides to order to order a sentence that differs from the negotiated plea, that you have the right to withdraw your plea of guilty?
Yes, sir.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that if you are placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
You understand that you are not allowed to possess nor use a firearm while on probation?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
You understand that you waive any and all defenses, including any mental health defenses, by entering your plea of guilty today?
Yes, sir.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand all these rights?
Yes, sir.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charge of theft by receiving stolen property?
Guilty.
Count 2, possession of a firearm or knife during the commission of a felony.
Guilty.
Count 3, fleeing and attempting to elude.
Guilty.
Count 4, criminal damage to property in the second degree.
Guilty.
Count 5, possession of a firearm by a convicted felon.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
You understand that unless counsel is substituted or permitted to withdraw, that defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes, sir.
You understand that you have only 12 months from today for misdemeanor and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, sir.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea.
Yes, sir.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
Yes, sir.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on January 5th of 2022, law enforcement had arrested Mr. Vihency Ross while recovering a stolen 2018 BMW near 2125 Joseph E. Boone Avenue in the city of Atlanta inside Fulton County. The vehicle had been reported stolen by the owner, Miss Lakeisha Williams, earlier that day. And OnStar advised that they were tracking the BMW to 395 Robin Hood Drive, and officers responded to the area but could not locate it. And at approximately 4 p.m., law enforcement received information that the vehicle was in the Joseph E. Boone area, and the vehicle was quickly located. Short time later, law enforcement observed Mr. Ross enter the BMW's driver door and start the ignition. Law enforcement followed Mr. Ross until GSP could conduct a takedown. Georgia State Patrol troopers caught up to Mr. Ross and the BMW near MLK Drive and Westview Avenue, activated their marked patrol cars, and the BMW sped away and crashed into a power pole. Law enforcement observed a single occupant, Mr. Ross, exit the vehicle and run into a nearby cemetery on foot. When he became exhausted, he laid on the ground and surrendered. A firearm, law enforcement recovered a Smith & Wesson 9mm handgun from the front driver's seat. It was on top of the seat cushion. And a check of the Smith & Wesson, the firearm returned stolen from the owner, Mr. Gerald Jones. Counsel, do you stipulate there's a factual basis for this plea?
Yes, we would stipulate that as a factual basis for the plea.
Thank you. Your Honor, we have reached out to Ms. Williams several times, unable to get her on the phone. However, the information provided during the indictment stage and the fair market value of the totaled vehicle is, at that time, was $29,500, which is why that is part of the restitution figure, which has been stipulated to by defense. Additionally, the firearm, we were able to speak, and I have spoken several times to the owner of the firearm, Mr. Gerald Jones. He is fine with the recommendation. He is saying he just wants his gun back. He actually sent me an email asking me to ask the court for an order to release it. But the time that the state is asking for is so that Mr. Ross will be able to pay that amount of restitution. And we ask that the court accept this recommendation.
Ms. Tucson, is Mr. Ross on probation now for any case?
No, Judge, no active probation for him.
Okay. Ms. Jackson, criminal history information on Mr. Ross?
Yes, Your Honor. The defendant has 15 cycles. The defendant's last arrest was June 26, 2023 in Noonan, Georgia, for possession of Schedule I controlled substance and possession of marijuana less than an ounce. There was no disposition for that arrest. He does appear to have an outstanding hold out of North Carolina for larceny. The date on that warrant was January 9th, 2023. And he does have a prior felony conviction that was in 2016 for possession of a firearm by a convicted felon. And he received first offender treatment in 2014 for robbery. That case was sealed October 7th, 2022. Nothing in addition, Your Honor.
Thank you. Are you able to check on that? You did or you will? Okay. Will you? You need to what? Okay. Hey, Mr. Ross, do you have an ID on you? Can you just share that? You'll get it back, I promise. Can you share that with Deputy Gordon? Thank you. All right, Ms. Taylor, what do you want to share with me?
Judge, that this is a negotiated plea. My only issue was with the restitution issue. As we know, generally, insurance pays these damages, and the state has indicated they have not had any recent communication with the owner of that vehicle. That was one of the reasons we were agreeing to the negotiated plea in the case of obviously the theft by receiving. He acknowledges he knows it wasn't his car. Someone let him drive the car, and obviously I acknowledge there's a factual basis for the plea. My only issue is with the restitution, and that I would think that the insurance company would have to be the one, or the owner of the vehicle. And at this point, that we have no, I don't want to fight the issue of restitution, but I don't want to stipulate to $29,000 of restitution, but we don't have anything from the victim in the case that's her loss, that the insurance company didn't cover the loss. And the insurance company is demanding restitution in this case. So that's my issue with the restitution.
Okay. No, those are all fair points. My guess is an insurance company would seek restitution if they knew this was going on. And I don't intend for anyone to get a double recovery. So if Miss Williams was made whole through insurance, then insurance needs to be made whole. And it may be that yes, Ms. Williams was out $1,000 for a deductible or something, but we need to gather that data. So I'm going to table the question of restitution, and it may be that the state can get more information.
But I would ask that you go along with the negotiated plea in the case.
Okay. Mr. Ross, is there anything you want to add?
No, sir.
Are you working these days?
Yes, sir.
What do you do?
Cut hair.
Your own salon, or you have a chair somewhere else, or people call you and you come over, or where do you work?
People call me and I come over.
Okay, so you're a mobile
Yes, sir.
hair guy. And do you stay with family or friends?
Yes, sir.
Which is like your residence? Is it with relatives or with
Grandmother.
your grandmother?
Yes, sir.
Okay, is it in Fulton County?
Yes, sir.
All right. Did you know Ms. Williams, the person who owned the car?
No, sir.
Were you injured in the accident?
No, sir.
Okay, you just made it into the cemetery and that's sort of where it ended.
Yes, sir.
Okay. All right. Well, Mr. Ross, I find there's a factual basis for your plea, and that your plea is knowing and voluntary, that you've understood what we've been talking about and that no one forced you to enter the plea. Do you agree with that?
Yes, sir.
I'm going to sentence you under the Probation Options Management Act, which means that while you're on probation, if you have minor or technical violations, you and probation will handle that. But if it is more serious, you getting arrested again, something like that, like down in Noonan while you were on bond, that will come back to me. Ms. Taylor, can we sign electronically the indictment on your behalf?
Yes, Judge.
And Mr. Peoples, we can sign for you?
Yes, Your Honor.
Mr. Ross, is it okay if we put your signature electronically on the indictment indicating your guilty plea?
Yes, sir.
Okay. So here's how we're going to handle restitution. I'm not imposing any restitution right now, but I'm leaving it open and we'll amend the sentence. If Mr. Peoples, you or anyone from the DA's office can get any, it doesn't need to be all that sophisticated, documentation from Ms. Williams about what happened with insurance. And she may just say, it's Allstate and here's the claim number. And then your investigator can reach out to Allstate and they will very quickly get you information about what they are out. And then obviously Ms. Williams is entitled to any deductible that she paid. But like Ms. Taylor, I'm not comfortable saying 29 grand to Ms. Williams unless we know that it was completely uninsured, which of course it couldn't be. So if you sort that out and circle back with some information, then we can just through email work with Ms. Taylor. And then if she wants a hearing, we'll certainly have that hearing. But I think if you get the standard documents, it's not one that we would need to bring everyone into court.
Right, Your Honor.
So, Mr. Ross, I am going to largely follow the recommendation, but here's what I'm going to do. On counts 1, 3, 4, and 5, your sentence is, let me look at that number again, 5 years to serve 5 months with the balance on probation. And you served 174 days. You just missed 6 months. So you've already served 5 months. You're not going back into custody. 5 years to serve 5 months, balance on probation. Count 2 has to run consecutive, and it has to be 5 years. So that'll be consecutive to count 1. And that's probated as well. However, those final 5 years of probation can be suspended if there haven't been any issues on probation, and there's no restitution still remaining. So you're going to have 4 years and 7 months of probation on counts 1, 3, 4, and 5. And you're going to do all that probation. If at the end of that, there's no restitution left, and there may never be any restitution, but if there's none left, and probation has gone well, then those final 5 years of probation I'll suspend. But if it turns out it's $29,000 of restitution, that's going to take a while to pay. And so I don't mind there being additional probation that's simply there so that you keep paying down what you owe either Ms. Williams or Allstate or State Farm or whoever was insuring that BMW X1 that you crashed into the power pole. Special condition of probation number 1 is that you take a theft course, and probation can help line something like that up. 2, you'll stay away from Ms. Williams, although it sounds like she is a stranger to you. I think you said there were locations or a location.
Not the locations, Your Honor,
Just Ms. Williams?
And Mr. Gerald Jones.
Oh, the gun guy. Okay. All right. You may know neither of them, but the guy who actually owned the gun that was sitting on the front seat of the car you were driving, that's Mr. Jones. You'll stay away from him as well. Nothing about restitution right now. But I am going to require, this is the main tweak I'm doing, that to get you to that 180 days, which is 6 days, that you spend 3 weekends in jail. So this is a special condition of your probation. And those weekends will start, since you told me you don't have a job where you're necessarily working on weekends, but you work as people call you and say, hey, can you come do my hair? Starting the weekend of September 23rd, but it's actually the Friday is the 22nd. So for 3 consecutive weekends, by 5 p.m., you show up at Rice Street, check yourself in, and they get you out by 5 p.m. on Sunday. Those 3 weekends in a row. You don't want to miss one, because it's part of probation. They'll be checking, and that'll be a violation of your probation. And that's it. That'll get you to the 180 days. But rather than locking you up right now, it'll just be on those weekends. You'll turn yourself in, you'll get out, and that's less disruptive to whatever else you've got going on in your life. Now, that is arguably a slightly more severe sentence than your lawyer negotiated. She had negotiated 10 serve 1, but reduced to time served. And I'm adding those 6 days in the form of those 3 weekends as a condition of your probation. Do you still want to go forward with this plea? Or do you want to say, no, thank you, I withdraw my plea and I'd rather go to trial on these charges?
Go forward.
Okay. Do you have any questions about any of the conditions of probation or the way I structured your sentence?
No, sir.
Okay. Ms. Taylor, do you have anything else on behalf of Mr. Ross?
Nothing else, Judge. You covered everything.
All right, Mr. Peoples, anything else from you?
No, Your Honor, thank you.
All right, probation, I may need to change the dates of those weekends. Let's find out from Ms. Tucson when you're even going to meet your probation officer, because if you haven't actually plugged in with probation, then those weekends are too soon. I just need to move them maybe into October or something. Ms. Tucson?
Yes, Judge, I'm here. Usually the way it's working now, because of the remodeling, they are reaching out for new intakes within 10 days. So that's why we usually put, 10 business days. So I would say he would be contacted by someone no later than the 26th.
Okay, I'll move those weekends a little later then, so we don't run into any issue. Do you need to get address information from Mr. Ross?
Yes, please.
19.
Okay, go ahead, Mr. Ross.
1907 Detroit Avenue, Northwest Atlanta, Georgia, 30314.
1907 Detroit Avenue.
Northwest.
You said Northwest?
Yes, ma'am.
And what's your phone number?
404-820-6801.
Is this your direct number
Yes, ma'am.
where I could send you reporting instructions?
Yes, ma'am.
Okay, and this is the verifiable address.
Yes, ma'am.
And who do you live there with?
Grandmother.
Okay.
Ms. Tucson, do you want maybe a backup number, emergency number in case if something is wrong with Mr. Ross's number?
Yes, grandmother's number or yours?
My grandmother number 404-732-2125.
404-732-2125. And what is her name?
Charlie Ross.
Okay, you will
Spell
be
it.
pardon me?
I was asking to spell it for you. The first name.
CHARLIE.
Okay, I got it. You this will be a verifiable address. If probation is unable to reach you, you will get a non-report for this. Okay.
Yes, ma'am.
Okay, and to clarify your sentence, what we'll do is just the first 3 weekends in October. So starting October 6th, that's a Friday, 5 p.m., you turn yourself in by 5. You get out by Sunday at 5, you turn yourself in at 3, you get out at 3, but by 5 o'clock on October 6th, then it's October 13th and October 20th, those 3 weekends. That'll actually be written into your final disposition. So you want to get that from Ms. Taylor, so you don't forget. Because as I said, if you miss those, probation tells me, and then I'm just going to sign a warrant, and you will do more than 6 days waiting to clear up that warrant. Okay?
Yes, sir.
All right. Thank you, everyone. And you are free to go.
Thank you, Judge. My big excuse.
Yes, ma'am.
Y'all have a good weekend.
You too.
And Your Honor, if it would please the court, if we could have a brief recess, I can reach out to Ms. Luncheon.
With a new and improved number?
Yes.
Okay. Let me hear from Ms. Wood. Did Bobby Bradley ever show up? Nope. All right. So that'll be a bench warrant. You were talking with a few people about a few things.
Yes, Judge. We can have final plea conversation with Mr. Creamer and Mr. Waterford.
Okay. Got it. We need Mr. Peoples for Creamer, and we do for Weatherford as well, unless Mr. Jordan knows what the offers are.
I could handle this part, Your Honor, and then just reach out to her briefly after.
And then you're gonna have a plea on Elder, I think that's with Mr. Jordan, so.
Okay, well, why don't we do Creamer and Weatherford so they can get out of here? And then when we're taking the elder plea, then Mr. Peoples can speak with Ms. Luncheon. So, Mr. Creamer, come on up to the podium, please. All right, Mr. Creamer, you have 2 cases, 20 SC 176182, where you're charged with theft by taking, and 23 SC 187626, where you're charged with aggravated assault, couple of firearms offenses, and aggravated stalking. Mr. Peoples, if Mr. Creamer wanted to resolve his 2 cases today, what would the state be recommending?
Your Honor, the global recommendation from the state would be a 10-serve-2 completion of a theft awareness course, stay away from the incident locations and the victims, and that would be today.
Okay, and Mr. Creamer has not already served 2 years across his, you would envision him going back into custody?
Double checking, Your Honor. Unless Attorney Wood knows off the bat.
I don't think it was anything near that, Judge.
Okay.
Right.
But I don't believe that it's that.
Yeah.
Okay. So, Mr. Creamer, you understand the state's recommendation. Mr. Peoples would be recommending that you serve 2 years in custody. You get credit for whatever time you've already served, but it sounds like you'd go back into custody, be on probation for a long time, stay away from the victims in the cases, and take a class. You understand that?
Correct.
Okay. Ms. Wood could advocate for a different sentence. If I were to sentence you today to more than what Ms. Wood asked for, you could withdraw your plea. No questions asked. Nope, Judge, that's not what I'm interested in, and we'll just move your cases to a trial calendar. After today, we could have that same exercise where I hear a recommendation from the state, I hear one from your lawyer, I land wherever I land. You will not be able to withdraw your plea after today if you don't like the sentence you get. You understand that?
Correct.
Okay. And this recommendation from the state, 10 to serve 2, is their recommendation today. It may not be that tomorrow or the next day. It might go up, might go down, but you don't have an ability to say, no, you need to bring back that offer you had for me on September 8th. You understand that?
Correct.
Great. You understand it all. Understanding those things, Mr. Creamer, do you want to go forward today with a plea in your two cases, or do you want me to move these to our October trial calendar?
Move it.
Move it?
Correct.
Okay. You'll need to be back here. I'm assuming you are on that calendar. Let me look. Yes. So you'll be here on October 27th. If you haven't resolved the cases before then, and I'll get one last report from your lawyer and the prosecutor. And if we need to have a trial, I'm assuming we would go forward with what strikes me as the more serious case, the aggravated stalking case, if we're trying Mr. Creamer's cases. Okay. Any idea how his bond didn't get revoked on the older case when the new case came along? Or it's not new, it's in indictment number is new only.
Correct, Judge.
So it's an old incident.
They're both from early 2020.
Okay. That makes sense. Mr. Creamer, do you have any questions about anything we've been talking about?
No.
Okay. So I will see you in late October, whatever the conditions of your bond are, and there probably were some pretty meaningful ones in this more recent indictment about staying away from folks. You need to continue to comply with those. All right?
Okay.
Great. Then I will see you then.
Thank you, Judge.
And he's already coming up. Mr. Weatherford. We ready? All right, this is position 11, 23 SC 187-200, State versus Jordan Weatherford. He and his lawyer at the podium. Mr. Peoples is here. Mr. Weatherford, you're charged with criminal attempt to commit armed robbery and possession of a weapon during commission of that attempt. Mr. Peoples, what's the state's recommendation?
Your Honor, the state's recommendation would be 15 serve 3, a weapons forfeiture and a theft course and a stay away from the incident location and the victim.
Okay. And would that require a deviation? I don't know what the sentence range is for attempted armed robbery.
It's Attorney Wood and I were working it through. It's the sentence range is 1 to 30.
Oh, well, that's within it.
Attempt is for specific charges is 1 to 30.
Okay. So Mr. Weatherford, if you were to enter a plea today in your case, you heard what Mr. Peoples would recommend, 15 to serve 3, which I assume means you go back into custody. A lot of probation, a little bit of prison time, and then some conditions of that probation. Do you have any questions about what that recommendation is?
No, sir.
Okay. Ms. Wood could recommend something different. If I sentenced you to something more than what Ms. Wood recommended, you could withdraw your plea today. You understand that?
Yes, sir.
After today, you could still enter a plea. That's what most people do rather than go to trial. But whatever happens during that plea after today, regardless of what your lawyer recommends, if I impose a sentence that's a legal sentence, but it may be more than what Ms. Wood asked for, you would not be able to withdraw your plea. You understand?
Yes, sir.
Okay. Lastly, this offer of 15 to serve 3 is the state's offer today. They may make you a better offer in the future. It may get worse. You don't control what happens after today with the state's offer. Do you understand?
Yes, sir.
Great. Understanding all those things, Mr. Weatherford, do you want to enter a plea today to these charges or have me move your case to a trial calendar?
Move it to trial calendar.
That's what we'll do. We will see you back here on October 27th. You'll get something in the mail, assuming you haven't moved. If you have moved, you better let the clerk know because we go by what's in the system.
Yes.
You need to keep that current. But as long as Ms. Wood has good contact information for you, she'll be wanting to talk to you before that calendar anyway to say, do we really want to try this? Do we want to try to work it out? I've got an updated offer, whatever's going on. She'll be reaching out to you. Okay.
Okay.
Any questions?
No, sir.
Ms. Wood, anything else on behalf of Mr. Weatherford?
No, Your Honor, thank you.
No discovery issues?
No, Your Honor. There is an unindicted CP case that I'm hopeful if we reach a non-trial resolution on this one, that we'll be able to wrap that one up as well.
Got it. Mr. Peoples, anything else in Mr. Weatherford's situation?
Nothing further, Your Honor, just that if we put something on the data case, we'll let the court know.
Okay. Otherwise, I'll see everyone in late October.
Thank you.
Thanks for being here, Mr. Weatherford. You're free to go.
And Your Honor, I'll just step outside briefly.
Okay. Ms. Elder, come on up.
Your Honor, this will be a misdemeanor plea. So Ms. Elder is charged with 2 counts of cruelty. First, the state will be motioning to dismiss count 2, and the state will be asking to reduce count 1 to battery, OCGA 16-5-.
Just regular old battery.
Yes, sir.
Okay. Thanks for flagging that.
Yes.
Ms. Wood, are you ready?
Yes, Judge.
And Ms. Elder, are you ready?
Yes, sir.
Okay. You're going to need to speak up louder when we get rolling, so Ms. Rivers, the court reporter, can hear you, okay?
Yes, sir.
Great. This is 22 SC 184949, State versus Stephanie Elder. Ms. Elder is here in court with her other lawyer, Ms. Wood. Mr. Jordan is handling this for the state. It sounds like, Ms. Elder, this will be what we call a misdemeanor plea. You have 2 felony charges, but the state, and only the state has the authority to do this. They're going to reduce one of those felonies to a misdemeanor and then dismiss the other one. Is that your understanding?
Yes, I'm sorry.
Okay, great. Mr. Jordan's going to put you under oath and ask you a bunch of questions. You've heard the questions now several times because other people have been taking pleas. Make sure you answer loudly and truthfully. And then if you've got questions of your own, let Ms. Wood or me know, okay?
Yes, sir.
All right, Mr. Jordan.
Thank you. Ms. Elder, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you very much. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Stephanie Elder.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
I'm 40, high school, some college.
Okay. Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with 1 count of battery in this indictment?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney, Ms. Wood, about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Ms. Wood, are you satisfied that your client has a full understanding of this proceeding?
I am.
Do you also waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
So waived.
Ms. Elder, do you recall having been arrested on this charge?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Ms. Wood, do you know of any outstanding warrants that are related to these charges?
I do not.
Ms. Elder, do you understand that you're entering a guilty plea to 1 count of battery?
Yes, sir.
In Your Honor, just for the court's purposes, the minimum for battery is 1 day in custody and the maximum is 12 months. Ms. Elder, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as previously stated, the state is reducing count 1 from cruelty in the first degree to children and moving to dismiss count 2. The state's recommendation for count 1 is 12 months probation. The only special condition of probation would be no violent contact. with the victim, Ms. Heaven Weems, and that is the daughter of Ms. Elder. Ms. Elder, are you aware that the court does not have to accept that recommendation?
Yes, sir.
Are you aware that the court can sentence you to the maximum on this charge?
Yes, sir.
Do you understand that if you are placed on probation, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea?
Yes, sir.
Do you understand that if you are not a United States citizen, a guilty plea conviction would affect your immigration status and may result in deportation?
Yes, sir.
And Ms. Wood, I did not see any prior arrest for Ms. Elder. Does she intend on using her first offender?
She does not.
Okay. Ms. Elder, do you understand that you waive any and all defenses, including any mental health offenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the sole charge of battery and indictment number 22 SC 184949?
Guilty. I'm sorry.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes, sir.
Do you understand that you have only 30 days in which to appeal your conviction based on your plea today?
Yes, sir.
Do you understand that since this is a misdemeanor charge, you have 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Your Honor, for a factual basis, if this case had gone to trial, the state would have been able to show beyond a reasonable doubt that, my apologies, Your Honor. On February 21st of 2020, an officer from the College Police Department, actually a young girl came into the police department and stated with tears rolling down her face that she would like to call her dad because her mom was being abusive towards her. The officer allowed Ms. Heaven Weems to call her father. She did later tell police officers that Ms. Elder began to beat her with a type of shoe called a slide. She did state that it broke her skin. She also stated that this was not the first time that this had happened, and that she was also hit with a speaker cord. She did say that the speaker cord caused bruising. Warrants were taken out at that time, Your Honor. I believe that Ms. Elder was arrested the same day for originally the two offenses of cruelty to children in the first degree. We've spoken with Mr. Weems, Mr. Gary Weems, who is the father of Heaven Weems. He actually told us, and I believe DFACS records pretty much back this up, that custody of the child, even though she was originally given to Mr. Gary Weems, that within a week or so, the child was placed back in Mrs. Elder's care. I've reviewed the DFACS records. While there have been visits since this incident, there's no allegations of any further physical violence or abuse. The child, whom was 11 years old at the time of the incident, was never taken to the hospital. There's no medical records that show any particular injuries. In fairness, Your Honor, I believe that this may have been overcharged. While it is a very serious allegation, there were never any real records to be able to really put a stamp on cruelty to children in the first degree. So we do believe that this is a fair negotiated resolution. I did attempt to reach Mr. Weems again today. I was not able to successfully reach him in regards to the misdemeanor resolution, but given prior conversations with the state, I believe that he would have no issue with this negotiated resolution. We would ask that Your Honor accept this resolution. Ms. Elder has, I believe this may have been her first arrest.
Okay, thank you. Ms. Jackson, do you have any criminal history information on Ms. Elder?
She does not have any prior arrests on file, Your Honor.
Thank you. Ms. Wood?
Thank you, Judge. This is her first and only arrest. She's 40 years old. I note that because this is pretty rare for our courtroom for someone to have made it 40 years without any interactions with law enforcement. So she's very proud of that, as she should be. She's a high school graduate. She has a college education, lifelong Atlanta resident. Judge, part of the reason that she decided to enter into a plea today is because having this open felony for almost 3 years has really hindered her life. She's lost job opportunities because of it. So that is part of the reason she wanted to avoid a trial. She also did not want to put her daughter through the process. She and her daughter are both involved in family counseling through Chris 180. And I believe that will continue. And we just ask that you accept the state's recommendation in this case.
Ms. Elder, how often do you and Heaven go to counseling?
They actually just started because if they had a white list or whatnot, but they have started. She has been to at least 4 sessions now.
Okay, how often does she go?
She, like I said, she just started, so she's only been there 4 times.
Right, but does she go once a month, once a week?
She goes like 4 times a week.
Oh my gosh, she goes 4 times a week? Is it after school? How does it not interfere with school?
They come and pick her up about 3:30 and bring her back at 7. And
that's a lot of counseling. Mm-hmm. Have you gone to any of it?
The one that they recommend for me is in Alpharetta. So I haven't, I just got mine.
Okay.
Referred.
Yeah, that's not real convenient.
It's not, but it is what it is.
It is what it is. How many kids do you have?
5.
Is Heaven youngest, oldest, somewhere in the middle?
She's the 4th child.
Okay. Do they all live with you?
Yes, sir.
How old is the oldest?
19.
And that's a male or female?
Female.
She lives in your household?
Yes, sir.
Is she working?
No, sir.
Did she finish high school?
No, sir.
Okay. What's she up to?
She's about to have a baby.
Oh, well, she's up to something.
Yeah.
Okay. Will that be your first grandchild?
Yes, sir.
Okay. And will that grandchild live in your house also?
Probably for the first couple of months.
Okay. How young is the youngest of your kids?
He's 13. He'll be 14 in November.
Heaven can't be that much older.
She's next. They're right beside each other.
Okay. All right. So if she's 14, is she in 8th grade, 7th grade?
She's in 9th grade.
9th grade. Okay. Where does she go to school?
She's online right now.
Why is she online?
She has since the incident, she just felt like she can go as far as she can go without any consequences. So she ended up getting kicked out of school, and she has a lawyer right now for truancy or whatnot. Oh. And she likes to fight. So the best thing for me, because I don't have transportation, I took a lot of losses. Going back and forth to the school, I put in school online.
Is she doing it?
She has no choice, or she's going to be violated.
Okay. Interesting. And how is the youngest doing?
He's great. He's great.
He goes to school?
Yes, he goes to school.
All right. Do you have any questions about anything we discussed?
No, sir.
I find there's a factual basis for your plea, and that your plea is knowing and voluntary. Ms. Wood, can someone from my staff sign the indictment on your behalf?
Yes, please.
Mr. Jordan?
Yes, sir.
And Ms. Elder, can we sign your name on there saying guilty to that one misdemeanor?
Yes, sir.
Okay. Well, I'll follow the joint recommendation, sentence you to 12 months probation. Two conditions. One, obviously, no violent contact with heaven. That'd be a crime anyway. But two, it's going to be a requirement of your probation that you start up that Chris 180 counseling. And it sounds like you want to, even though it's in Alpharetta, but it's going to be part of your probation. So you'll need to document that you're going to those sessions.
Yes, sir.
Okay. I think that's it. Ms. Wood, Ms. Nelson's going to send you the contact information so that you got it. So Ms. Elder, misdemeanor probation works differently from felony probation. We're not going to ask Ms. Tucson to chat with you. You will be reaching out to, I think you reach out, but they may be reaching out to you, this company that runs misdemeanor probation. It's important that you plug in with them, and you may need to come in for an initial session just to meet with them and learn who your officer is going to be. Okay.
Okay.
All right. If there's nothing else, then if Ms. Wood doesn't need you to stick around, you're free to go.
Thank you.
Yes, yes, my number and- Yes, there we go. You take it.
So we've got to figure out what we're doing with Mr. James and Mr. K. And then we just have Mr. Jones's revocation.
I'm ready on Mr. Jones. Mr. Peoples and I are still working out one thing on Mr. K.
Okay.
But I'm ready on Mr. Jones.
All right. And what's the word, Mr. Peoples? Oh, Mr. Peoples was just here. Okay. If I can ask Ms. Luncheon. Ms. Luncheon, are we sorting out Mr. James's cases today, or are we going to need to get him another lawyer?
I believe I just got off the phone with Attorney Luncheon. I think
Okay. She may be talking to her client. Should we, while we're waiting, do Mr. Jones, the revocation? Okay. You two are here for what case? Oh, you made it just in time. Okay.
I did, and I wish I'd seen it before, but it's extremely recent also.
Right, yeah.
Like August, like last month.
Like not even a month ago, yeah.
So I wouldn't have caught that. I'm fine with it. I mean, if you send it on, we'll still do the global, it'll just be 3 of them.
Yeah, so we'll let her know.
Right. Don't. Oh.
Okay, position 13 is State versus Anthony Jones. We got the right Jones this time. I think we brought your dad over last time. He was mad and you were probably frustrated. You didn't get to come to court. Sorry about that. This is 2 days in a row that we have had. Does he have the same name? Yeah. You're gonna have to speak out loud as we go through this.
Yes, sir.
Okay. Yesterday we had the same situation where there was a father and son with identical name, but we got the right one this time. So we're 2 for 2. 18 SC 161453, State versus Anthony Jones. You are on probation for aggravated assault in that case, and I signed a warrant in May of this year with an allegation that you violated your probation by, in February of this year, committing a new crime. You were a bad pedestrian. I think you jaywalked. And then in March, you weren't living where you told people you were living. So I think it's jaywalking plus you have the technical violation of having changed addresses without updating probation. Ms. Tucson, how much probation remains for Mr. Jones?
1 month and 19 days on this case.
Well, all right. Ms. Wood, is Mr. Jones admitting to these violations?
Admitting, Judge.
Okay. And how long has Mr. Jones been in?
179 days.
Okay. And what are you recommending we do?
Revoke the balance, Judge.
Okay.
Same from the state, Your Honor.
All right. And give him credit for time served.
Yes, Judge.
Got it. I think that makes a lot of sense. Ms. Tucson, is Mr. Jones on probation in any other case in Georgia?
Sorry, I thought I had left it on mute. It looks like violations. No, that case ended already as well. No, that one ended. So just this one.
All right. Where are you going to go when you get out? Right there. Is that mom?
Nah, that's my sister.
Sister? Okay. And you'll be able to stay with her? All right. Do you have a job? Something to go back to?
Yes,
Doing what?
construction.
Okay. A specific company or sort of you pick up work as it comes along?
Nah, I have like you heard of Jalen Ramsey?
Huh?
I work for his brother dad.
Really?
Yes.
Huh. Okay. How did you learn that that's Jalen Ramsey's brother's dad? So they have the same mom, different dads?
No, it's his nephew.
Oh, got it. The guy you work for
Yeah,
is Jalen Ramsey's
uncle.
uncle. Got it. How did you learn that that was Jalen Ramsey's uncle?
Oh, he told me personally.
Yeah, he told you. You know who my nephew is? Okay, got it. Mr. Jones, I find that you did violate your probation by jaywalking and moving. And you've been in for a long time. I'm going to revoke the balance of your probation. You'll get credit for time served. You served more than 1 month and 19 days. So you'll be all done. You probably won't be released today, given what time it is. You go back to the jail. You ought to be released tomorrow. What I told another gentleman already is if you are still in Monday morning, call Ms. Wood, have your sister call Ms. Wood, or anyone else they know at the public defender's office. They'll reach out to me and I'll make sure you get released. But it ought to happen this weekend. Okay.
I appreciate you a lot.
Okay. If you really want to appreciate me, don't do any more jaywalking. Yes, ma'am.
I have one scenario. I don't want him to be banned from Old National because that's where he always goes. He used to stay from Old National.
Okay. That's where sister comes in. He's not on probation anymore. So I can do this, stay away from All National. But that's not, I mean, that's just me saying it. Your brother has finished this case. It's now done. There's no more probation. Exactly. So you just need to say, hey, if you want the electricity to work in this house, you better stay away from Old National or it's going to get awfully hot in your life. And you may know who else is, maybe Jalen Ramsey could show up and say, I will break every bone in your body if you go to Old National because he's big enough to do that. But that's up to Anthony to decide now. I'm not an authority figure anymore if I ever was in his life.
So he's completely off probation.
Yes, ma'am. When he gets out, it's a long time. And it sounds like this wasn't his only hiccup. How old are you? Not you.
24.
24. Kids?
I got 3, but I'm not in two of their lives because their mama be on some other stuff.
Okay, she's got her own issues. Well, I want you to be in the lives of your kids. It's hard to do if you're going over to Old National and doing whatever your sister says you're doing. But life is complicated. I hope this job is there for you and you sort of keep your head down and try to do that kind of stuff. Anything else, Mr. Peoples?
No, Your Honor.
Ms. Wood?
No, Your Honor, thank you.
Good luck, Mr. Jones.
Good luck. Appreciate you.
All right.
You're welcome.
If you could do Mr. Plea.
Okay, okay,
There's a little bit of a hiccup.
all right. Yeah, the first case seems kind of serious.
Now there's a third case, Judge.
The third case, he was jaywalking too. Although it's a darting, that's different. We've had cases with darting.
Yeah.
There's a third case. We're ready for Mr. K, please. Yeah. Mr. K, you're going to come on up to the podium right here. One second. Okay. We're here with Mr. K, positions 9 and 10 on our final plea calendar. But I am hearing that there's a third case. We have 2, but is the third an unindicted case or it's in another jurisdiction?
It's an unindicted case, Your Honor. 23 CP 221038. A fleeing and attempting to elude, felony fleeing and felony possession of methamphetamine, and the remaining charges look as though they're driving offenses and they're all misdemeanors.
Okay. Why does, I'm looking at it now, and there was a waiver of a preliminary hearing, maybe to try to sort things out.
Yes.
What is the third case? Tell me what the hiccup is.
So essentially, Your Honor, where we are is that we worked out a negotiated resolution. So because myself nor Attorney Wood, and I don't want to speak for you, it hadn't come up on our radar, we would have worked to have it accused for today as part of the global resolution. I don't believe that it will change any time or anything as it relates to that. It's just that the state at this point would ask to place on the next available calendar so that I can at least get it accused. And then
as opposed to, I don't know what's being negotiated here. Is the armed robbery and the aggravated assaults, are they not what they appear, or is this a pretty serious resolution that's been negotiated in terms of time to be served? Because if it's in that direction, one, we could go ahead and do these 2 pleas, and you could get on the record that should your office end up accusing or indicting the CP case, that any sentence would run concurrently with this and would be no greater than that. That would do 2 things. One, Mr. K could move forward if he's going into DOC custody. 2, that case wouldn't come here if it got indicted. It would go wherever, but it would be on the record that would run concurrently. The other thing, and the reason why I was asking about the scope of the recommendation, is that if it's a pretty meaningful sentence, another approach would be to say we're going to just NPGJ the CP case. And that may be outside your band of authority. I'm not putting you in a box on that one. It's just, if I'm making these numbers up, but if Mr. K is going away for 5 or more years on the armed robbery, then query whether we even need to spin wheels on that other, because it doesn't sound like anyone got hurt. It's not a big other affecting crime. It wasn't a good thing. It may be symptomatic of what's behind all this other stuff, i.e. an addiction.
I think the court is right, Your Honor, so then I think we could do that.
Now, I want to be clear, I'm twisting no arms. I'm just throwing out options that might move Mr. K's cases forward. He's on the October calendar, so bringing everyone back before then is fine with me. We're all here, and Mr. K has family here, so we could do something with it.
So I think there was a breakdown in communication between myself and the pre-indictment attorney. First of all, I think
Meaning your colleague or someone? Okay.
Because the preliminary hearing was yesterday for that case, and I don't appear that often in front of Judge Drake, and so there was a conversation about the case getting dismissed, and then I saw that there was a waiver done, and in the system yesterday. And so with that being said, I think I can talk to Mr. K again and do what you're proposing. My concern is that I do want him to be done with 901 Rice Street as soon as possible. And I didn't want him to have to go down the road and then come back for the CP case whenever it finally does get indicted.
So he wouldn't necessarily have to come back because it could be handled virtually. We take pleas occasionally for folks who are in DOC custody, especially if it's going to be a concurrent kind of thing. If the state's not willing to dismiss the case when someone's got a longer sentence already being served for another Fulton case. And I'm going to repeat, and then you and Mr. K can talk about it in private. I'm not pushing in any particular direction. This just seems like a good time to resolve these two, and especially if we lock into the record, the outcome of the CP case would be, at worst for Mr. K, a concurrent sentence of no greater length, and at best it could be NPGJ. I mean, the state then would have the freedom to move in the direction they want. Then it may make sense to lock these two in. Do you two want to talk for a moment about that?
Yes.
Okay. Why don't you do that? Do we have an update from Ms. Luncheon? You're letting Mr. Jordan go?
Yeah.
Okay.
Yes, Judge.
Hey, Ms. Luncheon. How are things?
We have worked out a negotiated plea to both cases.
Okay. Do you want to pivot and do that while Ms. Wood is talking with Mr. K?
Yes, Your Honor.
Okay, great. Then let's get Ms. Luncheon on the screen. And then Mr. James, you need to come out of hibernation.
There he is. Judge, he did tell me his phone was on like 10%. So
Yikes.
I'm hoping he can last through this or
Okay.
get to a charger, but I just wanted to warn everyone.
All right, Mr. James, can you hear us?
Yes, my honor.
All right. We're going to get started. There he was. Prosecutor moved right over there. Are you ready to go, Mr. Peoples?
Yes, Your Honor.
Let me add you.
Are you able to hear me?
Your screen's not on. So if you don't mind, it's not you, it's our system. But if you don't mind going back to the witness stand or standing at the podium, wherever you'd rather be. If you want to sit, then it's witness stand. Mm-hmm.
Are you able to hear me, Ms. Luncheon?
I am.
There we go. Okay, so positions 4 and 5 are both State versus Rakeem James, 22 SC 184771, 23 SC 187165. Mr. James, you are not in court, which is okay by me, but I need you to tell me on the record that you waive your right to be here in the courthouse. Are you okay not being here in the courthouse?
Yes, my honor.
Okay. And your lawyer, Ms. Luncheon, is not wherever you are. You've got trees, she's got office buildings. And that's okay too. It just means she's not right by your side. Are you okay proceeding with Ms. Luncheon in a different place from where you are?
Yes.
Okay, if you need to speak with her in private, will you let me know?
Yes, my honor.
Okay. Then Mr. Peoples, if you want to put Mr. James under oath, we can get rolling.
Yes, Your Honor. Will you raise your right hand? Best you can in the screen. You solemnly swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Amen.
Thank you. Will you state your true, correct, and legal name?
Rakeem DeAndre James.
Can you spell it for the record?
RAKEEM JAMES.
And are you at this time taking or under the influence of any drugs, medication, or alcohol?
No.
Is there a medication that you normally take that you have not been given today?
No, sir.
What's the highest level of education that you've completed?
7th grade.
You said 7th grade?
Yes.
Do you have your GED?
No.
are you able to read, write, and fully understand the English language?
Yes.
Do you understand that you're charged with the following offenses? In indictment 22 SC 184771, theft by receiving stolen property with a sentence range of 1 to 5 years. Count 2, reckless driving, which is a misdemeanor with a sentence range of 1 day up to 12 months, and misdemeanor obstruction of law enforcement with a sentence range of 1 day up to 12 months. Count 23 SC 187165. Count 1, aggravated assault with a sentence range of 1 to 20 years. Count 2, possession of a firearm during the commission of a felony with a sentence range of 5 years to run consecutively. And count 3, receipt, possession, or transport of a firearm by a convicted felon, which carries a sentence range of 1 to 5 years. You understand that?
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
You understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yeah.
You need any more time to discuss this case with your attorney?
No.
You're satisfied with their services?
Yes.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
We do.
Mr. James, you understand that this is a negotiated plea of guilty, which means that the state's recommendation would be, Your Honor, the total recommendation we'll be asking is 5 years of probation, completion of a theft course, in indictment ending in 165, we would be asking that it be reduced to simple assault, and that count number 2 be null prost.
So the felony in 165 would be the firearm by convicted felon.
Correct, Your Honor.
Okay, got it.
Do you understand that?
Mr.
And
James, he's talking to you.
Sorry. Do you understand that, Mr. James?
Yes.
You understand that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have the right to withdraw your plea.
Yes.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts.
Yes.
You understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation, without being subject to revocation for the balance of the sentence.
Yes.
You understand that you are not allowed to possess nor use a firearm while on probation.
Yes.
Are you a citizen of the United States?
Yes.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty.
Yes.
There are certain rights that you give up by entering your plea today, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal or convicted of these charges after a trial. You understand these rights?
Yes.
Has anyone used any force, threats, or promises which has caused you to enter your this guilty plea against your will?
No.
Attorney Luncheon, are you proceeding under offered or under a guilty plea?
For the indictment ending in 165, Mr. James did want to proceed via Alford. And we can talk more about that when it's our turn, if the judge would like.
Okay.
Yep. Yeah. Well, when we get there, you can help me understand. And I sometimes get it when I hear a recitation of the facts, but I'll be sure to ask you, Ms. Luncheon, about that.
Mr. James, are you pleading guilty because you've decided it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
Yes. My phone, I'm sorry, I thought my phone was for the doc.
Yeah, he looks like he's probably running for a charger or something like that.
Okay, can you plug it in?
Trying to get a charger right now.
Yeah, why don't you hurry to a charger?
Hello?
Hey, you there?
Yeah, I had to tell my niece she a baby. That's why I went outside because I had kids in the house.
Okay, well, we're gonna keep going. So what was your last question?
How do you plead to the charges in indictment ending in 771?
Guilty.
And in the indictment ending in 165?
That's the one, the Alpha.
Yes, sir.
Okay.
Yeah.
Is your plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes.
You understand that you have only 12 months from today for a misdemeanor and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea. Mr. James?
That's you, Mr. James. Are you listening?
He's having to move again. I think it got a little raucous in there.
Yes, I hear you. Hello?
Okay. Do you have a room you can go into that might be a little quiet?
Yes. Hello? Hello?
Yep. All right, let's keep going.
You understand any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself?
Yes.
Thank you. Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on October 15th of 2020, Mr. Floyd Brewer reported a theft of his vehicle. A 2018 Hyundai was stolen. He told officers that he'd walked to a convenience store and encountered someone known as Big Baby. This person asked Mr. Brewer to provide a ride for a woman and children who were at a different location. Mr. Brewer spoke to the woman and received a payment of $40, so he agreed. Mr. Brewer walked into the store, realized that he no longer had the keys to the car and that Big Baby was gone along with the vehicle. Law enforcement was able to, a license plate reader advised that there was a hit on a stolen Hyundai nearby. And law enforcement spotted eyes on the vehicle a short time later with two black males inside. Law enforcement were able to get a description of the individuals he had seen driving the stolen vehicle. One, a black male with dreads, a black shirt and blue jeans, and the other was a heavyset black male who had been the driver of the vehicle. One of the males was detained while the other ran. A citizen approached officers to report that the other individual had just run through the breezeway of the apartment complex. They were identified as Mr. Keon Adderley, who my understanding is an alias of Mr. James. Counsel, do you stipulate this factual basis for this plea?
We do.
And Your Honor, in 23 SC 187165, on September 5th of 2020, Mr. Contavious Floyd went to confront the person that had robbed him a few days ago. Mr. Floyd went to 154 Gordon Terrace to find the suspect, Mr. Rakeem James. Once they got there, Mr. Floyd was standing in the driveway exchanging words with Mr. James when it's alleged that Mr. James pulled out a firearm. Mr. Law enforcement was able to put together a photo lineup with Mr. Floyd's driver's license, and he was identified. Counsel, do you stipulate there's a factual basis for this plea?
We do.
Your Honor, on ending in 165, the state's reason for the reduction is that according to the facts of this, there's and I'm sure Attorney Luncheon would put forward if this had proceeded to trial, that there's clearly a self-defense claim there that Mr. Floyd went to Mr. James to confront him. So that's the reason for this reduction.
Okay. And can you give me the date again, please, for the 771 allegation?
Yes, Your Honor. I have to go back 1 second. October 15th, 2020.
All right, thank you. Okay, Ms. Jackson, do you have any criminal history information for Mr. James?
He has 18 cycles. The last arrest was July the 9th, 2023 in DeKalb County for cruelty to children in the 3rd degree and battery family violence. There was no disposition for that arrest. He does appear to be on probation in Clayton County for aggravated assault and criminal damage to property. That disposition date was May the 8th, 2023, and the term is for 4 years. In addition to that, he appears to have 2 open cases in Clayton County, one for criminal damage to property in the 2nd degree, and one for unauthorized possession of a prohibited items by an inmate. I'm so sorry, Your Honor. And he does have misdemeanor convictions. That was in 2021 in Clayton County for battery, family violence, and cruelty to children in the 3rd degree. And he received a no-low contendory sentence in 2012 out of Hall County for a battery. And he does appear to have a history of probation violations, one in 2022, one in 2019, one in 2018. Nothing in addition, Your Honor.
Well, that was plenty. Thank you. All right. So Ms. Luncheon, what do you want to share with me about Mr. James?
Judge, I want to start with the aggravated assault case. I think there would have been several defenses had this gone to trial. One certainly might have been an immunity defense. We didn't file an immunity motion, but there might have been a self-defense defense there. Further, Judge, there would have, in this case, the state's victim, Contavious Floyd, is currently in custody for murder. It's our contention that he would have either been a hostile witness or would not have said what the state, alleges he would have said. It's my contention that he might have recanted, said that my client did not do this to him. There were some inconsistencies. I think the narrative said that there was an assault rifle that my client came up to and would have been standing a couple feet away from him, but he only, got shot one time, but several shots were fired off. There were just a lot of inconsistencies and the story didn't quite make sense. Mr. James, we talked extensively about this case, including his prior criminal history and what could have happened had he been convicted. But from our viewpoint, he did want to plead guilty because he felt like it was in his best interest. We know that the state doesn't have to have physical evidence. They don't have to have a video of the shooting. They can proceed with, the video and the narrative that they have. That is enough to at least proceed to trial. And so ultimately, he decided that it would be in his best interest to plead guilty to the possession of a firearm charge. With respect to the theft by receiving charge, Judge, again, I don't know who Big Baby is. I don't know if they're trying to say that's my client. I don't know who that is. With respect to the car, I don't know if there's any reason for Mr. James to have known or should have known that it was stolen. I think that in that case, the reason he did want to go ahead and try to plead guilty under Alfred is because later on he did, there's an allegation that he was fleeing from police, which of course the state could use to say that he did know that the car was stolen.
Right.
He has been working, he paints houses, he has a child that's 4 years old. He lives in Stone Mountain currently, and he's been in Atlanta for the past about 13 to 15 years, Judge. So I know that there were lengthy reductions on this case. I know he does have a history, but that is why we wanted to work it out the way that we did due to the weaknesses in the case and to try to resolve this today via plea.
Okay. Mr. James, can you turn your screen back on, please? Where are you living these days? What county?
Stone Mountain, Georgia.
So you're in DeKalb?
Yes.
Okay. Ms. Tucson, is Mr. James being supervised out of DeKalb?
He is being supervised out of Clayton, actually.
When he reports for probation for these two new cases, old set of facts, but new convictions, will he report to DeKalb because of where he lives? Will he report to Fulton because that's where these cases are, or Clayton because that's where he's being supervised?
He will need to report to Clayton because that's where he's being supervised. And then they will, of course, these dockets will be in the computer. And because of the violation, a case was sent back to Clayton. So he's being supervised by Clayton. Once he gets all that situated, he could be transferred to the Stone Mountain, DeKalb County circuit, where he could then be supervised there. But as far as right now goes, when he's released, he will need to report to Clayton County.
Okay, well, he's released. So are you able to give a specific date for him to return to report to Clayton County since their office isn't being refurbished?
I can. And then also, Mr. James, do you have your probation officer's phone number?
So not right out here.
What's your phone number?
My phone number is 404-823-5702.
404-823-5703.
02.
I'm gonna have a hard time hearing you.
02.
02. Okay, and what is your current address?
If you have that, Ms. Luncheon, it sounds like Mr. James is having a little trouble getting a quiet space. Do you have his address?
It's getting on my nerves. They see I'm on court call. For my third address is 632 Berline Drive, Stone Mountain, Georgia.
632, what's the street name?
632 Berline Drive, Stone Mountain, Georgia.
How do you spell that street name?
Bralone.
Okay.
I still didn't catch all of that. Brayline?
Bralone. Bralone.
In Stone Mountain.
Yes.
Okay, I'm gonna give you a call with your officer's phone number. You will need to report to Clayton County and on September 19th.
Yeah, September 19th.
September 19th, that's correct. And they open at 8 a.m.
Ms. Luncheon, will you be able to send Mr. James an email or a text to that effect as well?
Yes, Judge, I'll do both.
Okay.
Would you be able to email me too?
Yes.
Okay,
And will you send me your email?
I will. I'll send it in the chat right at this moment.
Perfect.
Okay.
All right. Well, let me tell you what the sentence is going to be. We got a little bit ahead of things, but it was important for me to know where Mr. James was going to report and when he was going to report so he can take care of the various things he needs to take care of with probation. So Mr. James, I find there's a factual basis for both your pleas. I understand that one of your pleas is an offered plea. I understand why it is. I think that makes sense. I find that your pleas are knowing and voluntary. You've understood what we've talked about, and no one's forced you to enter these pleas. I'm sentencing you under the Probation Options Management Act. If you have a minor violation of probation, you and probation will solve that situation. If it's more serious, a new arrest or anything like that, that will come through me. Ms. Luncheon, may we sign your name to the two indictments?
Yes, Your Honor.
Mr. Peoples?
Yes, Your Honor.
And Mr. James, can we sign the indictments for you?
Yes.
Okay. I'm sentencing you on the case ending in 771, 5 years on count 1, 12 months, count 2, 12 months, count 3. They all run together, and that's all probated. In the case ending in 165, count 1 has been reduced to a misdemeanor. That's going to be 1 day to serve, and that will be, you'll get credit for time you did serve in that case. And then count 2, oh, this is complicated. Count 2's been dismissed, so never mind, it's not complicated anymore. Count 1 will be 12 months, which is the misdemeanor. Count 2 is dismissed, and count 3 is 5 years. Those will run concurrently with each other. They will be probated, so that's a 5-year probated sentence. Also, it'll run together with your sentence in the case ending in 771. If any firearm was seized from you in the case ending in 165, you are forfeiting that. And in the case ending in 771, it'll be a requirement that you take a theft course. Mr. Peoples, anything else in Mr. James's 2 cases? Ms. Luncheon, anything else?
Nothing further.
Okay. We already talked about reporting instructions. Ms. Tucson, I appreciate the information you shared with me. I think that Mr. James can manage that when he reports to probation in Clayton County. Do you need any other information from Mr. James?
No, Judge. I sent Ms. Sunshine my information, and then I can call him and give him his probation officer's number. And she'll send me the correct address, so that way I have it all together. So thank you.
You bet. Mr. James, do you have any questions?
No, Your Honor.
Okay. make sure you get to probation on that day, because if you don't, they're going to take out a warrant on these two cases for not having reported, okay?
Yes.
All right. That is it. Thank you, Ms. Luncheon.
Thank you, Judge.
Thank you.
Thank you, Mr. James. Thanks, Mr. Peoples.
Thank you.
So that would have been better to do in person. He has a little surprise waiting for him in Clayton County. Mr. K, I think that's all that's left.
Yes. Perfect. And let's run it. We're ready, Judge.
All right, Mr. K, come on up to the podium, please. So our last business of the day, positions 9 and 10, 23 SC 187184 and 23 SC 187209, both State versus Nicholas K. Mr. K is in court with Ms. Wood. Mr. Peoples is here in court. Mr. K, good afternoon.
Good afternoon.
Ms. Wood tells me you are ready to enter pleas in your two cases. Is that right?
That's right.
Okay. You have an unindicted case that we'll talk about a little bit today. You understand we're not resolving it today.
Yes.
Okay. Mr. Peoples is going to put you under oath. Once you're under oath, you'll need to answer all his questions truthfully and completely. You need to let me or Ms. Wood know if you've got any questions so that one of us can answer them. Will you do that?
I will.
Okay. When you're ready, Mr. Peoples.
Yes, Your Honor. Mr. K, will you raise your right hand as best you can? Solemnly swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you. We state you can lower your hand. We state your true, correct, and legal name.
Nicholas Anatoly K.
And can you spell it for the record?
NICHOLASANATOLY
Okay. Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No, I am not.
Is there a medication that you normally take that you have not been given today?
No.
How old are you?
25.
What is the highest level of education that you've completed?
High school.
So you completed high school?
Yeah.
Okay. So then are you able to read, write, and fully understand the English language?
I am.
You understand that you're charged with the following offenses. In 23 SC 187184, you are charged with the offense of count 1, armed robbery with a sentence range of 10 to 20 years. Counts 2 and 3, aggravated assault, which carry a sentence range of 1 to 20 years each. Count 4, possession of a firearm or knife during the commission of a felony, which carries a sentence range of 5 years to run consecutively. Count 5, possession of a firearm or knife during the commission of a felony, which carries a sentence of 5 years to run consecutively. Count 6, misdemeanor obstruction, which carries a sentence of up from 1 day up to 12 months. Count 7, a pedestrian darting out to the roadway, which carries a sentence range of 1 day up to 12 months. And count 8, pedestrian in the roadway, which carries a sentence range of 1 day up to 12 months. And then 23 SC 187209, count 1, burglary in the second degree, which carries a sentence range of 1 to 5 years. And count 2, loitering or prowling, which carries a sentence range of 1 day up to 12 months. Do you understand that?
I do.
You understand that you have the right to plead either guilty or not guilty to these charges?
I do.
You understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
I do.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in these indictments,
Yes, I
including
have.
any potential defenses?
Yes, I have.
Do you need more time to discuss these cases with your attorney?
No,
You're satisfied with their services?
I am.
Counsel, do you waive formal reading of the indictment?
So waived.
Indictments?
We do.
Do you waive any and all defects in the indictments, including any with respect to your client's name?
We do.
Mr. K, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be a sentence of, Your Honor, in indictment ending in 184, the state would be asking to null pros counts 5 through 8. And in indictment ending in 209, in null pros count number 2. And the global recommendation that we would ask is 15 years to serve 3, to include RSAT treatment. We would ask to, on count 1 of the indictment ending in 184, I understand that there is a mandatory minimum. We would ask to deviate in that time under OCGA 17-10-6.1E. You understand that, Mr. K?
I do.
Yes.
Yes.
You understand, however, that the court does not have to accept this recommendation, and the court can sentence you to the maximum on each charge. They can run those sentences consecutively or one after the other.
Yes.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have the right to withdraw your plea of guilty.
Yes.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts.
Yes.
You understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit without being subject to revocation for the balance of your sentence.
Yes.
Understand that you are not allowed to use nor possess a firearm while on probation.
Yes.
Are you a citizen of the United States?
I am.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty.
Yes.
There's also certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent, not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal or convicted of these charges after a trial.
Yes.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No.
Is your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges in indictment ending in 184?
Guilty.
And in indictment ending 209?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you have only a limited right to appeal this guilty plea conviction?
I do.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes.
You understand that you have only 12 months from today for a misdemeanor charge and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea.
Yes.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
Yes.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that for the indictment ending in 184, that on April 15th of 2022, law enforcement was flagged down at 2572 Lenox Road by Mr. Nathan Reeves, who advised that he was robbed at gunpoint by Mr. Nicholas K. while in the wooded homeless encampment area at that address. Mr. Reeves advised that he was in the wooded area to drop off a plate of food to a friend when Mr. K, who Mr. Reeves is also an acquaintance of, emerged from a tent with a black firearm in his hand and proceeded to pistol whip him. Mr. Reeves pistol whipped Mr. Reeves in the back of the head while stating to Mr. Reeves, quote, "Get the F out of here or I'll shoot you," before grabbing a hold of Mr. Reeves' bike and taking it. While examining Mr. Reeves, law enforcement noticed 2 lacerations on the back of his head where he said he'd been pistol whipped. Counsel, do you stipulate there's a factual basis for
We do.
this? And Your Honor,
Was the bike recovered? Is there restitution?
there's no indication that the bike was recovered, Your Honor, and I reached out, attempted to reach out to Mr. Reeves and had not heard back.
Okay.
And in indictment ending in 209. On March 17th of 2021, law enforcement was dispatched to 782 Peachtree Street in Fulton County to handle a call of a person prowling at the location. On arrival, they met with Latoya, Latoya Guest, Guest, who is an employee at that location. Upon speaking with Miss Guest, she stated that she was working at the front desk when she noticed a male wearing a red and black top and trying to force entry to the business center located on the 6th floor of the complex. Upon receiving a description of the male, law enforcement stayed on scene so they could review footage. Upon canvassing the area, they came to the intersection of Peachtree Street and 4th. At that time, they received a better description of the male. And upon watching the male at the intersection, they could see him taking off in a grayish green hat and wearing the red and black top, which was the key identifying factor from Miss Guest. Upon detaining the male, he was placed in the patrol car. And upon receiving physical evidence in the form of security footage, he was confirmed to be the burglar at that location. He was identified as Mr. Nicholas K. Counsel, do you stipulate the factual basis for this plea?
We do.
Thank you. Your Honor, the state is asking for this deviation number 17-10-6.1E. It appears that Mr. K is suffering from in the throes of addiction, and we believe that some RSAT treatment in lieu of long incarceration. We believe that this 3 years to serve to include RSAT is an appropriate resolution for this.
Okay. Ms. Jackson, last time for today. Any criminal history information for Mr. K?
He has 9 cycles. The last arrest was August the 16th, 2023 with the City of Atlanta Police Department for theft by taking and possession of methamphetamine and obstruction of an officer and fleeing or attempting to elude an officer and reckless conduct and criminal use of an article with an altered ID or mark. There was no disposition. Also, he appears to have an outstanding hold out of Decatur, Georgia for obstruction of an officer. The date on that warrant was June the 11th, 2023. There were no convictions listed in the GCIC, Your Honor. Nothing in addition.
Thank you, ma'am. Ms. Wood.
Thank you, Judge. Mr. K is 25 years old. He does have family support in the area. His mother, Faith, has been at every court date that I have had with him. She's very involved. He does struggle with addiction, Judge. I believe all 3 of his cases in Fulton and probably the cases in DeKalb and Gwinnett also stem from his addiction. He did spend some time at Sober Living of America. I know that's at least one rehab facility that he has attempted to work with. I'm not sure if there were others. I think the armed robbery case, as Mr. Peoples alluded to, there might have been some difficulties finding the gentleman at the homeless encampment to actually go forward with the trial and prove it. But it's Mr. K's desire. He's ready to get the ball rolling on his recovery. So we would ask that you accept the state's recommendation. He's actually built up a little bit of time already for a total of 353 days. I did send those dates to Ms. Nelson, but I'll put them on the record as well. From March 18th to 2021 through April 8th, 2021, he served 22 days for the burglary case. And then April 16th, 2022 through February 17th, 2023 for a total of 308 days for the armed robbery case. And then the new case that he's picked up, August 17th, 2023 until the present, so 23 days total. We are hopeful, Judge, that the sit-down time with RSAT will be beneficial for Mr. K, since it is something that he cannot walk away from. So we just ask that you accept the state's recommendation.
Okay, thank you. Mr. K, anything you want to add?
No, sir.
What drug or drugs do you struggle with the most?
Meth and alcohol.
When you were staying at a sober living facility, did they give you any treatment, or it was just a safe space to stay?
I got some treatment.
How long were you there?
About a month.
Why did you stop being there? Let me ask a different way. Did you leave on your own? Did they kick you out? Did you run out of money to pay for it? Why? What happened?
I think I ended up leaving.
You don't remember, or?
I ended up leaving, but I kept the job until.
What job did you have?
A forklift operator.
Is that a job you got through sober living, or you already had it?
I got it through sober living.
Okay. And when did you stop that job?
When like maybe a week after I left, because a new company took over, and they made us all reapply. Then they didn't like my background.
Okay. Is that the only job you've had, or have you had other jobs?
I've had other jobs.
What's the last job you had?
Hanging sprinkler pipe.
How long ago was that?
That was a couple of years ago.
Okay. All right. And you don't have any questions about anything?
No, sir.
Well, Mr. K, I find there's a factual basis in both your cases. It does sound like you are wrestling with addiction and the consequences of that. And that's as you struggle to hold down a job, but you need money. You're getting mixed up in stuff that just gets you locked up again and again. I also find that your plea is knowing and voluntary. Knowing means you've understood everything we talked about. You agree with that?
Yes.
And voluntary is just no one's forcing you to do this. You and your lawyer have consulted and you've decided this is the right way forward for you. Is that correct?
That's right.
I'm sentencing you under the Probation Options Management Act, which means while you're on probation, if you have a minor violation, you and probation will resolve that. But if you get arrested again or anything at that level of seriousness, that will come back to me. Ms. Wood, may my staff sign the two indictments indicating Mr. K's guilty pleas?
Yes, Judge.
They can sign for you. Okay. Mr. Peoples, can they sign for you?
Yes, Your Honor.
And Mr. K, is it all right if my staff signs electronically for you indicating your two guilty pleas?
Yes.
So in the case ending in 184, and hear me out as I march through all of this, I am going to sentence you on counts 1, 2, and 3 to, make sure I get this math right. To 5 years to serve 4 years with 1 year probated. And then count 4 has to be 5 years and has to run consecutive, and that will be probated. So your overall sentence in the case ending in 184, that's the taking the bicycle from Mr. Reeves and whacking him on the head. That is 10 years to serve 4 years with the balance probated. In the other case, there's only one charge left because the state's dismissed count 2. And the sentence there is 10 years to serve 4 years with the balance probated. You'll get credit for all the time you've been in. And I will recommend to the Department of Corrections that you participate in their RSAT program and their aftercare program. Let me explain why my sentence is a little bit different. One, I think that's plenty of probation. It's 6 years probation. When you get out, if you are still struggling, we'll know that soon enough. And there's a lot of probation to work with there. I'm extending your sentence by 1 year, in part because some of this is serious, but also because I want to make sure there's enough time for you to get through RSAT by recommending the aftercare as well. As soon as you finish RSAT, they will try to move you to transitional housing, like a halfway house. So you're still under sentence, but you're effectively on parole, because the whole point of aftercare is you've done RSAT. Now we want to get you working and plugging back into the community. So you ought to be released well before the 4 years are up, but you've already knocked out one of those years anyway through the time that you've served. And if I kept it at 3 years, it's really only 2 years, and they might not consider you for RSAT, because RSAT it doesn't have to, but it can take up to 18 months. And they might look at what time is left and say, it's not worth it. Then you just be doing time. And that keeps you clean, but it doesn't give you the tools that maybe would help you stay clean and maintain sobriety when you get out. So that's my explanation for doing 10 do 4 rather than 15 to do 3. That sentence is a little longer than what your lawyer asked for. And today, we didn't really talk about this, but it's good news for you, not bad. Today's your final plea date. Today, you can say, no, thank you. I was willing to do 3, but not 4, and back out of this with no questions asked. But just so you know, what'll happen is you'll go back to jail and we'll move your cases to a trial calendar. So it's not that, hey, you're done with your cases. It means that you just be waiting where you've been without getting treatment for a trial. But you're free to do that. And no one would talk about the fact that you tried to enter a guilty plea if you did go to trial. Last thing I want to talk about, and then you and Ms. Wood should discuss whether you want to take this sentence that I've given you and my explanation for it versus what was recommended. You have this open case, 23 CP 221038. I'm making clear on the record that if the state does indict that, their recommendation will be for something that is no longer than the sentence that I'm giving you. So I'm giving you 10 do 4. If they choose to indict that, whatever they recommend in that case has to be 10 do 4 or less, so that that sentence wouldn't make your sentence any longer, your overall sentence. Is that a fair representation of what the state's agreed to do?
It is, Your Honor, but I'll also be working to decline it as well.
Okay, so Mr. Peoples is going to do what he can, assuming you go forward with your plea, just to get that case up, to get it dismissed. If he's not able to do that because they look at it and what you were doing, driving and whatnot, was serious enough, the state has committed to recommend a sentence that would be equal to or less than the sentence that I'm imposing today. So it wouldn't stretch anything out further. Do you have any, I just said a whole bunch. Do you have any questions about anything I've said?
No, I don't.
Okay. Well, why don't you and Ms. Wood talk for a little bit about whether you want to go forward with the sentence I've come up with or withdraw your plea?
Thank you, Judge.
You're welcome. Ms. Jackson, appreciate your time. You are free to go and very soon start your weekend.
Thank you so much, Judge. Have a great one.
You too. Ms. Tucson, we need you to stick around just in case Mr. K goes forward with this, okay?
No problem. I'm here.
Great. Me too.
Swim him all the way out, Judge, he'll take it.
Well, we just need to see what Ms. Tucson has to say. So just come on back to the podium, so we get this on the record, Mr. K. So did you have enough time to speak with Ms. Wood about your options?
Yes,
Okay, and do you want to go forward with your pleas?
I do.
Okay, we'll do that. I'll get those final dispositions signed soon. Ms. Tucson, do you need to share any information with Mr. K about reporting to probation?
Not exactly, since he will be in custody for a while. Miss Wood, she did so kindly send me information for him. So I will have that in the computer, and then, of course, upon release, they will give him information to report, for probation. Department of Corrections will give it to him.
Great. Okay. Mr. K, I wish you good luck. I think treatment will be helpful, but in the end, it's you one day at a time, figuring out how you're going to move forward. You've got family support, which is real important as well. I hope you rely on that, okay? All right. Thank you, everyone.
Thank you, Judge. This is yours, Mr. King. I wrote my number down.
Thank you, Ms. Rivers, Ms. Nelson, and Ms.
All right, cool.
Tucson.
Okay, good to you. Thank you. Have a good one.